Mr. D'Souza?
Good morning, Your Honor.
Bless you.
Thank you.
Good morning, Your Honor.
Go ahead.
My name is, from Pleas of Court, my name is John Townsend.
Oh, okay.
I am the General Counsel for the Boston Public Health Commission.
Yeah, go ahead, Mr. Townsend.
Okay. We are the appellant defendant in this particular matter. This case does come before this court on an application for further appellate review by the plaintiff appellee of the appeals court's reversal of the judgment of the Superior Court and dismissal of the plaintiff's complaint for failure to following the proper presentment under Chapter 258, the Massachusetts Tort Claims Act. A brief recitation of facts, Your Honors. On or about September 8, 1998, the plaintiff, Emmanuel Daveiga, was allegedly injured by a falling ceiling tile when he was a resident at the Long Island Homeless Shelter, a program that is operated by the Boston Public Health Commission. The Boston Public Health Commission, you may recall, was created by an act of the legislature in 1996 as an independent political subdivision of the Commonwealth of Massachusetts. The act abolished the Department of Health and Hospitals and the trustees of health and hospitals of the city of Boston and created two new entities: the Boston Medical Center, which was a combination of the City Hospital and the Boston University Medical Center, and the Boston Public Health Commission, which took over the functions of the Board of Health for the City of Boston and the operations of the public health programs for the City of Boston, one of which was the homeless shelters in question today. On July 15, 1999, the plaintiff filed a notice of claim pursuant to Chapter 258 of the Massachusetts Tort Claims Act on the City of Boston. In addition, on September 1, 1999, the plaintiff also filed a notice of claim with the Attorney General of the Commonwealth. At no time did he file any sort of notice of claim with the Boston Public Health Commission. In July of 2000, the plaintiff filed suit in Suffolk Superior Court against the City of Boston. This suit was voluntarily dismissed by the plaintiff in September of that year, and in October, he filed suit against the Boston Public Health Commission. This was the first time that the Boston Public Health Commission had received any sort of notice regarding the claims of Mr. Daveiga. The Boston Public Health Commission filed a motion to dismiss for failure to properly present his claims pursuant to Chapter 258. The Superior Court denied that motion, finding that the Boston Public Health Commission may not be a public employer, that the service of notice of a claim on the mayor of the City of Boston was sufficient service of notice for the Boston Public Health Commission, and that an exception should be made for the plaintiff's defective presentment in this particular case based on public policy and the consideration of fairness.
Let me understand that the Superior Court, I've read the decision and it's a little uncertain. Did the Superior Court in essence say that the Public Health Commission was not a public employer, the City of Boston was the public employer for purposes of 258?
That'd be correct, Your Honor. That was the thrust of the opinion. In a footnote, the Superior Court did indeed state that the Public Health Commission may not even be included in the Massachusetts Tort Claims Act, Chapter 258.
But is that seriously pressed here? I mean, the fact that this claim may not even be included, is that, we're not dealing with that issue, are we? We're dealing with who the public employer is. Is it the city or is it the Public Health Commission?
That is indeed the issue. However, Your Honor, any time which a Superior Court judge does indeed find in one of its opinions that a governmental agency may indeed not be under the provisions of the Massachusetts Tort Claims Act does indeed raise a serious issue which I think needs to be determined by this Court. But the issue that, and then the Boston Public Health Commission did appeal that particular decision. The appeals court found for the Boston Public Health Commission dismissed the plaintiff's complaint due to the fact that the Boston Public Health Commission is a public employer and the present was defective.
Can I ask you just a background question? Does the City of Boston have its own public health department that enforces, the state sanitary code and things like that?
No, Your Honor.
That's what this organization does?
The Boston Public Health Commission is considered the Board of Health for the City of Boston. However, the enabling legislation of the Boston Public Health Commission does provide that certain enforcement provisions of the sanitary code would remain with the Inspectional Services Department. So things
of the City of Boston?
That's correct. So things such as the inspection of restaurants, which in another city may indeed be covered by the Health Board, the Department of Health, would be covered by the Inspection Services Department.
Does the Boston Public Health Commission have its own budget?
Yes, it does, Your
And
Honor.
do they get any money from the city of Boston?
It does, Your Honor.
Does it get any money from any other sources?
Yes, it does, Your Honor. The enabling legislation for the Boston Public Health Commission provides that it can charge fees, fines for its services. However, as I think the legislature knew in enacting this, the charging of fees for public health services does not generate a lot of revenue. Therefore, the city of Boston is required to provide for, make up, indeed, that particular amount of money that is the difference between the fees that are generated by the commission and its actual operating expenses.
Well, I'm a little confused by one of your answers to Justice Spina's question and something that was in one of the briefs. Is the commission a department of the city?
No, it is
No,
not.
it's not.
It is a separate independent political subdivision of the Commonwealth of Massachusetts.
Well, if you admit that it's a separate independent political subdivision, then how can the mayor be the proper authority to whom to make presentment?
Well, he's not.
It's not.
Precisely our point, Your Honor, that he is not the proper person to be presented on a notice of claim under Chapter 258. The city of Boston is a separate entity.
You have your own executive director,
That's correct.
and that's who you say should have been served with the presentment.
That's correct, Your Honor. The enabling legislation does provide for a board of directors for the Boston Public Health Commission that is indeed appointed by the mayor. However, the enabling legislation also provides for an executive officer of the commission, which would be the executive director that is appointed by the board.
The judge, as I recall, the Superior Court judge, points to some confusion in the statute, in this enabling legislation, as a basis for, I'm not sure what, in part as a basis for finding that the city remains the public employer, and in part, perhaps as a basis for excusing any misunderstanding on the subject, excusing the fact that it was filed with the mayor and not the Health Commission. But one of the things he points to is the language in the statute which says that the Health Commission shall be liable for torts in the same manner as the Department of Health and Hospitals, which was one of the predecessor agencies.
That's correct, Your Honor.
And liability and tort for the department, in fact, rested in the city, not separately in the department.
That's correct, Your Honor. Yes, both the plaintiff and the Superior Court hinged on a particular provision of the legislation that said that the Boston Public Health Commission may sue and be sued, prosecute claims, defend its property, and be liable in tort as the Department of Health and Hospitals before it. My argument with regards to that would be indeed that that would actually support the contention that the Boston Public Health Commission comes under the purview of Chapter 258. The Department of Health and Hospitals, as the Department of the City of Boston, was liable for its torts claims under the Chapter 258, and notice was provided to that particular agency through its executive officer, what the mayor would be. Now, the plaintiff would argue that because of that particular provision in the enabling legislation, it has to be exactly the same as the Department of Health and Hospitals. However, the Boston Public Health Commission is a separate entity. It should be liable for its torts under the purview of Chapter 258, and under 258, its executive officer, which is set out by the enabling legislation as the executive director, would be the proper party for presentment.
Does the mayor or the city council of Boston have an opportunity or the ability to appoint any employees of the Public Health Commission?
The only employees that has the ability to appoint, Your Honor, is the board members. The board members are appointed by the mayor, except the CEO of Boston Medical Center, who is a member, and confirmed by the city council.
Okay, where we do have a relationship between these two entities, the City of Boston and the Public Health Commission. Some of it's financial, some of it is personnel.
That's correct, Your Honor.
What's wrong with saying that the service on the mayor, at least in this case, is not really outside the realm of notice provisions that are required by Chapter 258? Why wasn't it at least effectively good notice?
You are correct, Your Honor. There are very close relationships between the Commission and the city, since indeed it is the Board of Health. However, the purpose of the notice provisions of Chapter 258 is to allow the executive officer of an entity, a governmental agency, to assess, investigate the particular claim, and decide whether it's reasonable for settlement. The mayor does not have the ability to investigate claims which involve the.
But he could pass it along to the Public Health Commission. I mean, the mayor certainly has an interest in the health, the financial health of the Public Health Commission, and the city of Boston does as well. What's wrong with saying that at least where that relationship exists, when the service was made on the mayor, at least that was good for purposes of the statute?
Well, first of all, there's no requirement that the mayor would actually have to provide that notice to the Public Health Commission. The statute explicitly says the executive officer of the governmental agency must be served. That would be the executive director. The enabling legislation does not provide for the mayor to be the executive officer. In fact, the executive officer of the Boston Public Health Commission, as well as the board, explicitly says will not be supervised or in any way overseen by the departments or the officers of the mayor of the city, except as otherwise provided in the statute. And the only provision for any sort of supervision that's provided for in the statute is with regards to the budget, and that the budget is submitted to the mayor, and the mayor can either accept it or reject it.
Would you concede that if the mayor had in fact sent this to the executive officer of the Boston Public Health Commission, that would be sufficient for presentment purposes?
I would not. I mean, there's obviously those particular very narrow exceptions that this court has prescribed with regards to actual notice or any sort of lulling involved here. But as far as the strict requirements of Chapter 258, it would be my position, to be the Commission's position, that notice does have to be served directly on the executive officer.
Even if actual notice was within the time frame, actual notice was given to the executive officer.
That would be correct.
So the fact that the city does receive these from time to time and does in fact pass them on to the Health Commission, in your view, is irrelevant.
That's correct, Your Honor. And just let me note that in the facts of the matter in this particular case is that did not happen, is that it was not passed on to the Commission. The first time the Commission ever received any notice of these particular claims were when the suit was filed against it in 2000. Just one final note, Your Honors, about regards to whether the application of the notice provisions of Chapter 258 are fair, because in essence, the Superior Court, in finding that the notice provisions were not followed, deemed it was not fair. Now, as I stated, the facts in this case, as found by the Appeals Court, do not fit with any of the narrow exceptions to notice provisions, such as presentment, the actual notice of presentment, or being lulled by the defendant's representations. The notice provisions of Chapter 258 are indeed not intended to be fair to the plaintiff. They are intended, in the words of this Court, to give notice to the official best able to ensure that the interests of the governmental agency are protected. The facts do establish that the Boston Public Health Commission is a public employer, that the Long Island Homeless Shelter is the sole responsibility for the Commission, and its executive officer, and that would be the official best able to investigate and settle these particular claims, never received any notice of those claims.
Just let me ask you this. If somebody wanted to find out who the executive of the Boston Public Health Commission was, how do you best go about doing that?
We are listed in the phone book. We do have a website which lists out who the executive officer is and has a little statement regarding to filing of claims against the Commission. And, of course, you can call us. We're available.
Well, I imagine you could call the Corporation Council of the City of Boston.
That's correct.
You could call. Okay. Thank you.
Thank you, Your Honor.
Mr. D'Souza?
Morning, Your Honors. Victor D'Souza on behalf of Emmanuel Daveiga. It is the appellee's position that the mayor of the city of Boston is the chief executive officer of the Boston Public Health Commission.
That's based on your interpretation of the enabling statute?
That and the case cited by the defendants, Weaver versus the Commonwealth. In the case cited by the, by the appellant, it says that the individual to whom presentment must be made is that officer charged with the overall financial, budgetary responsibility of the agency or the department.
That would
you-
make the mayor the person for presentment for a whole bunch of different agencies of the city, would it not?
especially this one, because under the enabling statute, if you read the enabling statute, sections 27, 28, and 26, it really puts the onus for budgetary and financial decisions with the mayor, including for all expenses, all obligations have to be approved by the mayor's office and the city council. There is an executive officer listed in the enabling statute, but that executive director that's identified and counsel for the appellant says should have gotten notice here is more in the genre of the executive director identified in the Lodge case, which was, I believe, a Superior Court case. In that case, the court looked to, I think the district attorney got notice, and the court said the attorney general should have gotten notice. And in that case, the court said that although the district attorney had some some personnel issues that he had to do, and he had to submit a budget, that did not rise to the level of chief executive officer. I submit that the chief executive in the Boston Public Health Commission identified under Section 2.4 is similar to the district attorney in the Lodge case. In the Lodge case, the court said that the attorney general should have gotten notice because the attorney general had supervisory and oversight over financial and budgetary issues. It's the same situation here. The mayor has absolute supervisory role over all budgetary matters, expenses, obligations of the Boston Public Health Commission. They have to submit that every single year, and the mayor has veto power and objection over the budget. Not only do they have to submit it every year, they had to submit it pre-formation, the year that they were forming this Boston Public Health Commission. And then after that, every single year, the mayor has supervisory over the budget and financial decisions.
Did the mayor also have the supervisory financial responsibilities over the predecessors of the Public Health Commission?
Yes, the predecessor of the Boston Public Health Commission, the Department of Health and Hospitals, also had a similar executive listed in their enabling statute. But again, the city and the mayor exercised ultimate financial and budgetary decisions in that matter, making this case more like Weaver and Lodge, where the mayor is really the chief financial officer of the chief executive officer of this commission.
But under the with respect to the predecessors of the Boston Public Health Commission, they were public entities that also had separate executive directors, and for purposes of Chapter 258, wasn't presentment required to be served upon those executive directors of the two predecessors of the Boston Health Commission?
No, Your Honor. In fact, the appellate court cases that were cited, Hurley, Holt, and there was one other, Emory Johnson. Those three cases, it was astonishing. In those three cases, the appellate court ruled that the mayor was the chief executive officer of, that the city, if I just, I know I have the, just beg your pardon for 1 second. In those cases, the appellate court held in all three cases that the city of Boston and the Department of Health and Hospitals were one and the same entity for tort liability purposes. One was a third-party workers' comp liability situation. The other case was liability for settling joint tortfeasors. And in those cases, the appellate court ruled on every single one that the Department of Health and Hospitals and the city of Boston are one and the same entity. They were co-employees of the same person. They were co-settlers.
Well, let me ask you, what's the point in the enabling legislation of saying that there is a chief executive of the agency?
I think there's administrative powers that this chief executive has, but I think when you look at Weaver and you look at Lodge, this chief executive that's identified in the enabling I don't want to say an underling, but subservient to the mayor with respect to the crucial element of budgetary and financial responsibility. The mayor has final say-so on all budgets, finances, obligations, and expenses. Everything has to be approved each fiscal year by the mayor.
But what's the enabling statute creates this Public Health Commission as a body politic and corporate and political subdivision of the Commonwealth, right? The prior legislation with respect to the Department of Health and Hospitals simply says there shall be in the city of Boston a department known as the Department of Health and Hospitals. Isn't this something different that's being created by this statute?
Well, the enabling statute for the Boston Public Health Commission also states that for all purposes hereunder, unless expressly enunciated otherwise, the Boston Public Health Commission will be a department of the city of Boston for all purposes, and that's cited, I think, in.
Now, I noticed that citation. I'm not sure what that language means in the context, and it's an interesting choice of words. On the other hand, the statute says all liabilities of the Department of Health and Services shall basically remain liabilities of the city in tort, but new liabilities are liabilities of this new body politic and corporate called the Boston Health Commission. It seems to me that they really are separating these two agencies in a legally sufficient manner.
I think for some, I would differ with that analogy, especially when it comes to tort liability, because really this is what was the focus of this case. When you look at tort liability, you have to look at the enabling statute 2711, which says that the Boston Public Health Commission will be held liable in the same manner as the old Department of Health and Hospitals. And in the old Department of Health and Hospitals, they were having tremendous success on these cases. They were winning these cases every time because they were saying us and the Department of Health and Hospitals in the city and the trustees are one and the same entity. 3 times we're one and the same entity. We're one and the same entity, and they kept winning. I submit that that's the reason why they put that language in the enabling statute as opposed to what Cambridge Public Health Commission put. They put a altogether different language.
There's an explanation for that, at least one provided by the Health Commission, and that is in Cambridge, the agency that was formed was a merger between a private hospital and a public hospital, and so there might be some question about whether 258 actually applies and who the public employer was, where that is not the case here.
Well, it's not that clear in here, because in this case, we also had a merger, too, of the university hospital and the city hospital.
But that's outside of this. That's not, is that overseen by the Boston Public Health Commission?
Well, they merged, so now the Boston Public Health Commission, it's one and the same. There was a merger in this statute.
I thought the statute created 2 entities, the Boston Medical Center and the Boston Public Health Commission. Is that not right?
Well, I could be confused on that point, but I do recall that in the enabling statute, there was a merger of a nonprofit corporation identified with the city, with the Boston Public Health Commission, or the city hospital and the university hospital having a merger. But from a practical matter, an attorney looking at this, who to send the letter to, obviously it would be best to send letters to as many people as possible, but we have to draw the line on this particular case, especially in light of the section in the enabling statute, which says that, this enabling statute should be interpreted broadly to give the most needy citizens redress in court. In words to that effect on 211, when you look at how the cases have treated these 2 entities in the past, namely the Department of Health and Hospitals and the city, and you see that they're one and the same entity on 3 different appellate court cases, and then you have this statute that says that the Department of Health and Hospitals, that the Boston Public Health Commission will be liable in the same manner as the old Department of Health and Hospitals. If you put 2 and 2 together, you'd say, well, if they're both the same entity, the city and the Department of Health and Hospitals, and that's the way they're going to be liable in this, well, notice to one is notice to both, since they're one and the same. So if I give notice to the mayor, then I'm giving notice to the Boston Public Health Commission pursuant to this enabling statute when I look at the cases that have decided this question in the past. And underlying all that, you have the supervisory role of the mayor over all expenses and financial and budgetary items in this agency, and you look at Weaver and Lodge, you're saying the mayor's the The mayor is the chief executive officer here. While they do identify a chief executive officer, that chief executive officer is more like the chief executive officer identified in the Lodge case. In the Lodge case, the chief executive officer did have some budgetary issues and personnel issues, but he came under the Attorney General, and they said, no, you should have sent it to the Attorney General, not to the district attorney, because the Attorney General exercises supervision over the budget and the financial and the finances of the department. Similarly here, the mayor exercises supervisory. If you look at 2.6, I believe 2.6, 2.7, 2.8, I mean, pre-formation of the agency, the mayor had approval and the city council had approval over all the budgets, and then after formation in 95, 90, 96, every single year, the mayor has to approve expenses, obligations, budgetary items. All of that has to be approved by the mayor. The nexus here is so close that this case, if you look at 211, which says it must be interpreted liberally, I think you have constructive notice, and to the Boston Public Health Commission, when you mail it to the mayor, and the attorney who argued the case in the Superior Court said routinely, when we get notice, if we get notice, we send it to the city, and the city gets notice, they send it to us. So there is a connection here. And if we give credence to what this enabling statute says, that it should be interpreted broadly and liberally to give remedies to the people that are being served by this committee, which Mr. Daveiga is one, a homeless man in a psychiatric hospital, I think you have to say that the notice was effective here to the mayor. And on a practical matter, one of the questions was put out by one of the justices about how do you go about identifying this. When you call, in fact, I called. When this case came into our office, I called to find out who owned the Long Island shelter. We put a call through to the tax assessor. They then transferred me to engineering, and I said, this is the area where the accident occurs, the Long Island shelter, and the response is the city property. You won't get a response, this is the Boston Public Health Commission's property. You're going to get a response, this is city property. And likewise, Mr. Daveiga, when he came into my office, I was on city property. No one ever says I was on Boston Public Health Commission's property. They're going to say what's being repeated to them, and what they see is city property, the tax assessor, engineering department, city owns that, it's tax exempt. They're not going to tell you it's the Boston Public Health Commission. So given the totality of the circumstances here, I would strongly recommend, I think, too, that
Is it part of your claim that you were lulled into believing that the city of Boston was, in fact, the proper entity upon which presentment was to be made?
Well, pre-litigation, there wasn't much in the lulling aspect. Post-litigation, after suit was filed, there was a letter that came to my predecessor attorney on this. I managed to dig it out yesterday. There was a letter from the city to Attorney Alan Rahm from our office, and it said, based upon our discussions, which we don't know what those discussions were because Alan's no longer with the office, but based upon our discussions, it appears you may have sued the wrong entity. Please dismiss the city and bring in the right entity. Apparently there's been telephone discussions now between attorney and my office. So post-litigation, the city did say to us, to our office, that they're not the correct entity and that we should bring in.
And at that point, the suit was dismissed.
After we brought in the Boston Public Health Commission, then the suit was, then we voluntarily dismissed the case against the city based on that letter. Yes, Your Honor.
Okay,
we did voluntarily dismiss it.
Just in terms of timing, the letter from the city, I know this might be fairly close, came in prior to the end of the 2-year presentment period, did it not?
The letter of the city came in on September 12th of 2000. And this accident occurred, I believe, in 98.
September or August? So the letter came in after the 2 years.
September of 98, and we got the September 8th of 98.
All right.
September 8th of 98, and we got the letter on September 12th of 2000.
Okay, thank you.
You're welcome.